In this video, I'm going to talk you through the procedure that a case takes when it goes to and through the Supreme Court. So I promise it's much more interesting than that sounds. And what I hope you'll get out of this video is an understanding of all the different steps that are involved when the Supreme Court wants to take up a case. So we want to start just by understanding the overview of how the court system works. In the United States, we have trial courts, which are the ones that are down at the very bottom. So things like the district courts, the tax courts, the Court of Federal Claims, Veterans Appeals, etc. That's where, if you've ever watched Law & Order, that's where you have the introduction of evidence. That's where you have people raising the right hand and swearing to tell the truth, the whole truth, and nothing but the truth. You're going to hear my dog whining. Don't worry about it. This is also where you'll have a jury and they'll deliberate. There'll be opening and closing arguments, all of that stuff. That happens at that lowest level on this chart. In the middle level, so the courts of appeals, this is where you go if you feel like the lower court made a mistake. So at the appellate level of the courts are not basically doing a new trial. You don't have all of those things. You're not going to have testimony. You're not going to introduce evidence. There won't be a jury. Instead, the attorney, usually for the side that lost at the lower court, is going to make an argument about why the trial court made a mistake. Maybe they applied the wrong law. They allowed evidence that they shouldn't have. They might have used the law incorrectly, etc. And so everyone can appeal their case from the trial court to the appellate court, and the appellate court will hear them. Usually it's a 3-judge panel. You need to convince a majority of them, so that would be 2, to side in your favor. If you're still feeling like they're not doing the job correctly, probably because you lost, you can ask for the district court to hear your case en banc, which means the whole court. Usually it'll be 7 or 9 justices, several more, that will hear your case. And then if you're still not happy, that's where you can petition the Supreme Court to hear your case. So most cases that come before the Supreme Court start off in the district court, go to the U.S. Court of Appeals, and then ask for review out of the Supreme Court. Now, the courts of appeals are arranged by geographic district. So you'll see in this map, there are 11 numbered districts. Plus there's also, if you notice over there near the East Coast, there's also the DC Circuit and the Federal Circuit. So these are going to be additional district courts. There are 13 total. Notice that Tennessee is here in the 6th district, along with Kentucky, Ohio, and Michigan. Some of the districts have a relatively small geographic footprint. Like, for example, the 3rd district is Pennsylvania, New Jersey, Delaware, and the Virgin Islands, the U.S. Virgin Islands. Whereas some are very large, like the 9th Circuit district. This is where all of the West Coast and mountain states are, in addition to Hawaii, Guam, the Marshall Islands, and Alaska. So that one's very large. But when a case is heard by a circuit court of appeals in one of these circuits or one of these districts, then the decision that that circuit court of appeals makes is binding on all of the trial courts within that district. So if, for example, a case comes up from a trial court in Tennessee, it goes to the 6th Circuit Court of Appeals and they make a decision. That decision will then be precedent for all of the federal courts in the 6th Circuit. So a case that had the similar issue that comes up in Michigan, they would be bound by that precedent, but it wouldn't necessarily be a precedent in all of the other districts. It would only become a precedent, say, in the 11th district in Georgia, if the 11th district Circuit Court of Appeals had a similar case and ruled the same way. But it's also possible that on a similar or the same legal question, another circuit court of appeals in another district might resolve the case differently. And we'll come back to that in just a minute. So let me give you a sense of the scope of the federal judiciary. There are 94 trial courts in the federal court system. And let's just pause for a moment and make sure we're clear that we are talking about the federal or the national court system here. There's also state court and local court systems that are not included here. But there are 94 different trial courts in the United States. And in 2015, they heard just under 300,000 cases. The regional circuit courts, so there are 12 of them plus the DC circuit or the federal circuit, they heard 54,000 cases in 2015. And generally between 7 and 10,000 petitions annually come to the Supreme Court asking for the court to hear that case. Those are called petitions for certiorari, which we typically call just cert, because certiorari is a bit of a tongue twister. And of those, fewer than 80 are granted cert, or less than 1% annually. So that short video just gives you a sense of the volume of cases and how cases get to the doorstep of the Supreme Court. In the next one, I'll talk you through then what the court does and doesn't do and how they decide which cases they'll hear.